First of all, I would like to commend all counsel in this proceeding. I know it has been a difficult and lengthy one. I would like to thank the family members, witnesses, and media for your patience. Any delays that occurred at any point during these proceedings have been to protect and safeguard the rights of all involved in these proceedings. Mr. Duren, as we know, 12 qualified and impartial jurors, all citizens of Coos County, have unanimously found that you have committed the crimes as charged by the prosecutor, and the jurors returned verdicts of guilty on those charges. Accordingly, it is my sworn, please be seated.
Oh, okay.
Thank you. I will, thank you. Accordingly, it is my sworn duty under the state and federal constitutions to impose sentences upon you for those crimes. The sentences I impose will be in accordance with the sentencing laws as established by the New Hampshire legislature and within the protections afforded to you and on your behalf by those same state and federal constitutions. The sentencing remarks that I make here today are based upon the guilty verdicts as returned by the jury. In deciding upon the appropriate sentences, I have considered all relevant factors in mitigation and aggravation. I've also considered all of the goals of sentencing as I am required to do, which include punishment, rehabilitation, specific deterrence, and general deterrence. Matters that I've considered include the state's sentencing memorandum, which is 23 pages long. In it, it concludes a listing of comparable sentences, and for those of you who thankfully are not familiar with this process, it is typical for both the state and the defense to provide comparable cases for them to argue to indicate that a sentence should be more similar to this case or more similar to this other case. As we all know, and as both parties have acknowledged, no two cases are identical, especially in any murder case. Every murder case is unique. As I said, it is standard practice for the attorneys to argue by analogy relative to comparable sentences, and that is what has been done in this case by competent and experienced counsel on both sides. I've also reviewed completely every word, the sentencing memorandum proposed by the defendant, submitted by the defendant, 94 pages, which includes a detailed report from a military expert, Captain Art Cody, the report from a psychiatrist expert, Dr. Roger Pittman, 7 letters of support that were appended at the time, and 3 more letters of support received today and read into the record. I've also considered the impact statements from Mr. John King, Ms. Eliza Schmidt, hope I'm pronouncing that correctly, all others who spoke today in support of Caitlyn, all of the family members who spoke today in support of her. I've considered Mr. Duren's military service. I've considered the impact of Mr. Duren's actions and my sentence on all families who have been so affected by this tragedy. I've also considered Mr. Duren's lack of a criminal record. I've considered all of the remarks from both the prosecutors and the defense counsel today. Certain matters that I've not considered include the following: any allegations of criminal conduct that are not specifically before this court, any other allegations of domestic abuse which were not before this court. However, I will point out that I have considered Ms. Naffziger's stated fear of the defendant, which is demonstrated by virtue of the evidence proffered at trial, including by the defense, relative to the existence of a plan. So I have been asked to not consider any other allegations of domestic abuse, and I am not doing so. However, I am considering Ms. Naffziger's stated fear, as it was indicated, as can be inferred and as indicated based upon testimony which was introduced during trial. I am not considering the status of any custody disputes or remarks made about guardianship or family law proceedings which are not part of this proceeding here today, nor am I considering the impact of any financial disputes that may have occurred between the families after the events which are the subject of these proceedings. And finally, I am not considering, as requested by the defense, I'm not considering as part of my sentencing, there is no trial penalty, so to speak, which is I'm not holding against Mr. Duren his right under our constitutions to demand a trial and to hold the state to its burden of proof. I have thought a lot about this case before, during, and after the trial. I listened very carefully to the testimony of all witnesses during the trial and considered their credibility and demeanor, as did the jury. I know that they did. With respect to the goal of sentencing being specific deterrence, a lengthy incarceration does mean, with respect to Mr. Duren, that he has less opportunity to commit any further crime. Further, a suspended sentence with respect to the reckless conduct charge does assist the overall goal of having specific deterrence under the circumstances. With respect to punishment, Mr. Duren, you took a life. You argued at trial that it was justified, but the jury found differently. And the taking of a life necessitates a lengthy sentence. With respect to punishment, the court is not motivated by vengeance. There shall not be an eye for an eye, because an eye for an eye leaves everyone blind, as we know. And further, there must be some prospect, even if slim, but there must be some prospect for redemption and/or salvation. With respect to rehabilitation, for those of you who are not familiar, the New Hampshire Constitution does provide that the true design of all punishments is to reform and not to exterminate mankind. I would note that both proposals from the state and the defense do include the possibility of Mr. Duren earning time reductions for completion of programming. I understand the defense argument to indicate that those are not quite as substantive or substantial as the prosecution would have us believe, but I do note that those components are included in both proposals relative to rehabilitation. With respect to general deterrence, another factor which the court is entitled and must consider under these circumstances, the message that the taking of another life carries with it in this state and in this county is that the prospect of a severe punishment as a general, there must be a prospect of a severe punishment as a general consideration to reduce crime. Also, with respect to general deterrence, there is a domestic violence component to this case, which has been discussed and cannot be ignored. I would point to evidence that included during the trial, Mr. Duren, that you called your attorney about your options. And then almost directly after that, based upon my recall of the evidence, you did call the Berlin Police Department. What I would describe based upon as a proactive, tactical choice with respect to the circumstances that were presented to you at the time. And by that, it indicates that you knew that you had the option of calling the Berlin Police Department when confronted with the circumstances on February 29th. You could have called the Berlin Police in response to the actions that were confronting you at that time, which you had done previously. But on that night, you chose not to. I also need to make a few comments about deadly force as a justification for homicide. I hope and I pray that everyone in this courtroom and all those in the sound of my voice never find themselves needing to use deadly force to defend themselves or others. However, if that does happen and deadly force is used, if the user chooses to use it to defend others or to stand his or her ground, the message must be sent that the user must also stand their ground to take the consequences of their action, to take responsibility for the use of deadly force, and not to flee the scene. I've considered all factors relative to specific deterrence, rehabilitation, punishment, general deterrence, as I've said. Further, there has been much presented of the challenges that you have faced, Mr. Duren. I recognize and sympathize with the impact of those challenges. I would also like to state that I have not heard quite as much about the gifts that you have received. You were born an American citizen. You have two loving parents and others who surround you who love you. You had natural traits that allowed you to excel at an early age, as has been indicated by the evidence I've received. You've been blessed with not one, but two healthy children, which so many others would envy you for. You were gifted a pistol by your father as an heirloom, and you had the right to keep and bear that pistol as a right under our Constitution. Despite all these gifts that have been bestowed upon you, nothing changes the fact that, based upon all of the evidence, you shot the unarmed mother of your two young children in the head. I'm going to repeat that. You shot the unarmed mother of your two young children in the head. The citizens of New Hampshire and society at large demand, and the law that I must enforce clearly supports, a lengthy sentence under all of the circumstances that have been presented. So if I could have you please stand, Mr. Duren. By virtue of all of the considerations that I have described, and after considering all of the evidence during trial and during these sentencing proceedings, I am adopting the requested sentences from the state of New Hampshire with respect to each of the sentences. With respect to charge ID 223-7508C for a crime of second-degree murder knowing occurring on February 29th, 2024, you are hereby sentenced to the New Hampshire State Prison for not more than 45 years nor less than life. There is added to the minimum sentence a disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence, to be prorated for any part of the year. Pretrial confinement credit of 650 days. This sentence is to be served as follows. Stand committed. With respect to restitution, you shall pay restitution of $12,007.69 to victims' compensation. Restitution shall be paid through the correctional facility or Department of Corrections as directed by the probation/parole officer. A 17% administrative fee is assessed for the collection of restitution. The defendant is to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the correctional authority or probation/parole officer. Subject to the provisions of RSA 651-A:22-a, the Department of Corrections shall have the authority to award you earned time reductions against the minimum and maximum sentences for successful completion of programming while incarcerated. Law enforcement agencies may destroy the evidence or return evidence to its rightful owner. You are ordered to be of good behavior and comply with all terms of this sentence. Further, you shall not profit in any manner for your role in committing these offenses, nor may you assign your rights to any monetary profit or financial benefit to any other person. Specifically, you may not accept any payment, enter into any contract, or sell rights regarding any book, film, television show, radio show, website, podcast, or any other writing, recording, broadcast, or internet posting relating to the murder of Caitlyn Naffziger or to the defendant's actions therein. With respect to charge ID 221-7223C, I'm sorry, I skipped one. I'm going to go back. With respect to 221-7222C, which is a guilty verdict for reckless conduct with a deadly weapon, you are hereby sentenced to the New Hampshire State Prison for not more than 3.5 years, nor less than 7 years. There is added to the minimum sentence a disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence, to be prorated for any part of the year. Pretrial confinement credit of 0 days. This sentence is to be served as follows. 3.5 years of the minimum and 7 years of the maximum is suspended. Suspensions are conditioned upon good behavior and compliance with all of the terms of this order. Any suspended sentence may be imposed after a hearing at the request of the state. The suspended sentence begins today and ends 10 years from release on charge ID 223750-8C. This sentence is consecutive to case number and charge ID 2237508C. You are to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the correctional authority or probation/parole officer. Law enforcement agencies may destroy the evidence and return the evidence to its rightful owner. You are ordered to be of good behavior and comply with all terms of the sentence. Further, consistent with the state's request, you shall have no contact with the family of Caitlyn Naffziger, which includes Lori Smith, Bailey Naffziger, Heather Naffziger, and Brenda Plondon. The defendant shall have no contact, either directly or indirectly, including but not limited to contact in person, by mail, phone, email, text message, social messaging sites, or through third parties with ED and/or VD, unless such contact is solicited by ED and/or VD of their own volition, and such contact is in accordance with any applicable related agreements or court orders governing such contact. Further, the defendant must comply with any court orders concerning contact with ED and VD issued by any court having jurisdiction, including any orders issued by the Minnesota courts related to custody proceedings. Further, you shall not profit in any manner for your role in committing these offenses, nor may you assign your rights to any monetary profit or financial benefit to any other person. Specifically, you may not accept any payment, enter into any contract, or sell rights regarding any book, film, television show, radio show, website, podcast, or any other writing, recording, broadcast, or internet posting relating to the murder of Caitlyn Naffziger or for your actions therein. Finally, with respect to charge ID 221722-3C for a guilty verdict of endangering the welfare of a child, this conviction is for a misdemeanor. It does not include as an element of the offense the use or attempted use of physical force or the threatened use of a deadly weapon. The defendant is sentenced to the House of Corrections for a period of 1 year. Pretrial confinement is 0 days. This sentence is concurrent with case number and charge ID 223750-8C. You are ordered to have no contact with the individuals set forth in 221722-2C, either directly or indirectly, including but not limited to contact in person, by mail, phone, email, text message, social networking sites, and/or third parties. Law enforcement agencies may destroy the evidence or return the evidence to its rightful owner. You are ordered to be of good behavior and comply with all terms of the sentence. And further, you shall not profit in any manner for your role in committing these offenses, nor may you assign your rights to any monetary profit or financial benefit to any other person. Specifically, you may not accept any payment, enter into any contract, or sell rights regarding any book, film, television show, radio show, website, podcast, or any other writing, recording, broadcast, or internet posting relating to the murder of Caitlyn Naffziger or to the defendant's actions herein. Finally, out of administrative completeness, with respect to charge ID ending in 221772-1C, the guilty, which is the reckless second-degree murder charge, the finding of guilty will be maintained, but no sentence is assigned with respect to that charge, it being duplicative to the other charge of second-degree murder knowing. Again, by virtue of all of the factors I have considered today, I am adopting the sentencing recommendations from the state of New Hampshire. Attorney Duren, anything further at this time?
Nothing from the state.
Attorney Kettles.
No, Your Honor. Thank you, Judge. Mr. Duren, you are hereby notified that you have the right to apply for review of the state prison sentence imposed on you today. The application must be filed within 30 days after the date of the sentence, but not thereafter, except for good cause shown. If you file such an application, your sentence will be reviewed by a board of 3 members who will be either judicial referees and/or superior court judges. Review of the sentence may result in a decrease or an increase of the minimum or maximum term within the limits fixed by law, or there may be no change in the sentence. A form for making application, if you wish to do so, is set forth below. Judge, I'll just ask the record reflect that I'm going to hand Mr. Duren's attorneys a copy of this form, and the state has a similar application if they choose to apply.
Thank you, Clerk Kovalenko. To avoid any confusion, Attorney Kettles, again, I request again, any question or ambiguity relative to the sentences that are imposed for purposes of clarity.
Not for purposes of clarity.
Okay. Okay. Anything further on behalf of the state?
No, Your Honor.
Anything further on behalf of the defendant?
No, Your Honor.
Okay. Mr. Duren, good luck to you, sir. It is my duty to remand you to the Coos County Sheriff's Department for further processing. The court will be in recess.
All right.